Until 1976, getting a divorce was often a protracted, costly and unpleasant business.
The Whitlam government overturned this system based on fault and replaced it with what was meant to be a more civilised, less traumatic way of ending a marriage.
It's obviously going to make divorce easier. I'm not sure that that's a good thing.
It was one of the signature social reforms of the Whitlam government, a new Family Law Act and a special separate court to deal with it.
The new court that's established today includes within its structure a counselling and welfare service.
There would be no sordid public divorce cases, just no-fault divorce and the protection of the rights of children. But according to Camilla Nelson, one of the authors of a new book on the family court system, it has been an idea under assault almost from the start.
One of the more radical proposals put forward so far, the abolition of the family court system.
From the earliest days, the court was profoundly political. All the debates and the acrimony around changing gender roles, about the changing role of men in society, about equality and the family, all these debates took place through the prism of the family court.
The horrendous force of the bomb, which was booby-trapped to the Watsons' front door.
The backlash was no small thing. It culminated in a horrendous series of bomb attacks on family court judges and their families.
The family court bombings, they didn't explode in a vacuum. There were already a whole host of nascent men's rights groups. As soon as the bombs went off, everybody turned around and didn't condemn the bomber, they condemned the court.
Fast forward through repeated inquiries and changes to the court during the Howard era, which began the process of splitting some of the functions of the court into the federal court in 2006. And this week saw the formal death of the Great Whitlam experiment, as the standalone family court was subsumed by the Federal Circuit Court. The move had originally been announced by the then Attorney-General, Christian Porter, in 2018, despite the government already having tasked the Law Reform Commission to review the system.
We can have thousands of more matters heard and resolved quicker every year by this process of simplification.
Porter's move came as a surprise and blindsided groups like the Bar Association and the Law Council. But he said the changes could not wait because the family court was drowning in a backlog of delayed cases.
The lift doors open and the crowd is actually packed thick from 1 or 2 feet from the lift doors. And as you push your way through the crowds, you'll hear people negotiating settlements. They will be talking about pornography consumption, exchanging bank account details.
The government eventually got the reforms through the Senate earlier this year with the support of independent Senator Rex Patrick and One Nation. There are both practical and symbolic issues tied to the end of the court, questions about judicial expertise, the rights and protection of children, and whether the reforms will fix wait times. The government addressed some of the criticisms of its plans, but not everyone was convinced.
They have failed to address any of the fundamental problems plaguing the family law system, including the risk of family violence survivors falling through the cracks.
Continuing to do nothing to fix this problem is not an option. The proposed reforms are the least radical path to end unnecessary confusion, costs and delay.
But critics are still concerned that the symbolism of the change will be a perceived downgrading of the rights of children, central to the court's origins, and to the problem of domestic abuse, hardly seen as an issue in 1975, but now the bulk of the court's work.
Hi, I'm Lee Sales. Thanks for watching this story. If you'd like to watch more of 730's stories, they are on the left of your screen. And tap on the button below to subscribe and get the latest from ABC News.